My name is Lisa Palazzo. I work in the University Compliance Office, and I'm here today to talk about privacy management as it relates to health information. Specifically, we'll focus on HIPAA, and you've noticed the recording equipment, I'm sure. This session today will be recorded and will be on our website for future reference. For that reason, we're going to be holding questions till the end after the camera stops rolling. So to put the discussion of privacy of health information in a broader context, we consider individuals' privacy expectations in general. Like many of you in this room, I would be upset if certain information about me, my weight, my health conditions, my age, would be generally known and broadcasted. It pretty much goes without saying that we expect certain facts about us to be private. This is very much a part of American culture and what we're used to. Well, as a university, we have a lot of personal information about people by necessity. All that information that I just described could be found somewhere in the legitimate business records of Case Western. And although we come to hold this information appropriately, we all need to be aware of how it can be misused so that we can avoid any harms associated with that, like embarrassing or victimizing people through cyberbullying, gossip, or improper disclosure. Not just students, but we have information on staff, faculty, even relatives of these people, donors, and even research collaborators from other institutions. So in this playing field, we have some pretty important goals to develop and maintain a comprehensive privacy program. We want to continually identify our risks, create and update appropriate policies, train employees about privacy issues, and also keep abreast of how technology is changing and how this can affect privacy issues. We're taking steps in all of these areas, and today is focused on training employees, but also we hope that in the discussion following the presentation, you can help us identify risk areas. So we hold, as a university, a lot of personal information, and as you folks, most of whom are in IT or connected to IT, as you folks are aware, as more information is stored electronically as opposed to paper, storing and transmitting that information securely can be challenging. With an active understanding of the legal standards that we're held to, we can know what we're supposed to do to be proper stewards of this information. This slide shows some of the legal standards we're held to. You may have heard of FERPA. That focuses on the privacy of students' education records. And as I mentioned today, we're going to be focusing on HIPAA. HIPAA is the Health Insurance Portability and Accountability Act, and it tells about how organizations that hold individuals' protected health information can use and disclose it. It was enacted in '96, and this is a federal law which was enacted to improve the efficiency of healthcare delivery. HIPAA requires entities that receive federal healthcare support, like Medicare payments, to make their reimbursement requests electronically, instead of paper forms, which is what they used to do. So in making this operational change, Congress realized that the change in process had the potential to threaten patient privacy. So it asked Health and Human Services to enact rules regarding protection of privacy. And you know, if you take a step back, there are really some sound reasons why we should protect the privacy of this kind of information. First off, medical information is information that really most closely relates to our bodies and our minds, so it's therefore the most personal information there is about us. And also, if you ask many medical professionals, they would say that when patients know that their information is held in the strictest privacy and security, that they're more apt to have open, honest communications with the treatment provider so that they could get better care. Also, protecting privacy of medical information protects employees from health discrimination in the workplace. I'm sure you all have heard of HighTech. HighTech was enacted in '09 to promote the adoption of and the meaningful use, really, of health information technology. It provided $19 billion of incentive money for healthcare providers to switch over from paper to electronic health records, and also to develop a national electronic health information exchange. At the same time, it strengthened HIPAA by addressing how these changes would impact privacy. For example, one of the changes was increasing penalties for privacy violations. In response to HIPAA, Case Western enacted 27 HIPAA-related policies that provide our faculty and staff with information on how to manage HIPAA-protected health information. Our office is in the process of reviewing and updating these policies. But in the meantime, I encourage you to go see them. They provide detailed information on topics related to HIPAA, such as patient rights and how HIPAA relates to human subjects research. Generally, HIPAA applies to covered entities. And HIPAA defines covered entities as health plans, such as health insurers, healthcare clearinghouses. These are third-party organizations that handle or process medical information, and healthcare providers, so like doctors and nurses, who conduct certain financial and administrative transactions electronically. As a side note, for your healthcare providers, the existence of those certain electronic transactions is key. Only providers who engage in electronic communications regarding claims, payment, health plan enrollment, and other certain transactions are considered covered entities. So, for example, a doctor providing a service for free is not a covered entity under HIPAA. As an institution, Case Western Reserve University is not a covered entity. Certain components of Case, though, are. They do meet the definition of covered entity. This makes Case a hybrid entity. And this slide lists those covered entities of Case. And they're also called designated healthcare components. So it's the dental school faculty practice, the student health plan, the employee health plan, and one particular area of the School of Medicine that falls under the definition of covered entity. As a hybrid entity, looking at the university as a whole, we're in an interesting position because some of our covered entities, some of the designated healthcare components provide direct patient treatment, like the dental school, whereas others, like the employee health plan or student health plan, provide health coverage. So because of this, the types of health records, the types of HIPAA-related situations could vary greatly within Case. Also, many, as you know, as IT folks, many staff, many employees are called to assist covered entities and may come into contact with protected health information in the course of their jobs. That's why we need to be aware of how HIPAA can affect our activities. HIPAA includes the privacy rules and the security rules. The privacy rules are intended to protect the confidentiality of protected health information, PHI, whereas the security rules are intended to protect PHI in electronic formats. You may have heard that there are administrative, physical, and technical safeguards for PHI. So that originates with HIPAA. Protected health information, PHI, is information that relates to the physical or mental health of an individual, identifies the individual, or there's a reasonable basis to believe that the person can be identified using the information, and is created, received, transmitted, or maintained in any form by the covered entity. So by definition, PHI identifies an individual. HIPAA lists 18 identifiers that potentially can call out a person, can identify someone. When an identifier, which are listed on the slide, is used in combination with an individual's health information, then the information is PHI. So what are examples? Medical records, obviously, that have an identifier like name or medical record number, lab results, x-rays, health plan billing information. PHI is not just the records themselves, but the information from the records. So it's possible that two people standing in an elevator could be discussing a patient or a person discussing their PHI and be overheard by someone else. So that would be a disclosure of PHI or a HIPAA breach. Could be. Obviously, not everything is PHI, and we'll talk about some of those things right now. First off, de-identified data. This is information that doesn't actually identify an individual. This can include something that originally was PHI, but it's been redacted, the identifiers have been scrubbed. Education records. HIPAA explicitly excludes from its coverage records that are subject to FERPA. For example, imagine that as part of a study abroad program, we have some students here at Case going abroad for the summer, let's say, and they have the choice to disclose certain medical conditions they may have or medications they're taking. Even though it's medical information, it's not PHI because the university or the International Studies Office is not a covered entity. So that information wouldn't be covered under HIPAA. Employment records. Let's say I email my boss saying I'm homesick with pink eye. Well, that email is not PHI. Health treatment records of students at post-secondary schools. As those of you who may have attended one of our FERPA sessions know, there's been some confusion traditionally over whether FERPA or HIPAA governs student health records. We won't go into detail today, but the takeaway is for Case Western purposes, we generally treat student health records here at Case as FERPA records, not covered by HIPAA. Research records. HIPAA explicitly carves out research records as not being considered PHI. So you see from these examples that an individual's health-related information in the United States is treated sectorally. It could be protected in some situations, but not others. Also important to note is when it comes to health information, states have the power to enact stricter privacy laws. For example, Ohio has a law making it a crime to disclose patients' HIV status to unauthorized persons. So when you take a step back and think about it, a person's HIV status could arguably be on any number of our case records, including those housed as records within offices that are not HIPAA-covered entities. University Health Service, counseling services, clinical study research information. So even though that information isn't PHI under HIPAA, HIPAA really provides a best practices framework for us to look at how we could and should consider how to most carefully handle that kind of information. Now that we have a clear understanding of what PHI is and what it isn't, let's look at how covered entities can properly use and disclose it. To make sure we're all on the same page regarding terminology, we'll clarify. When I refer to using PHI, we mean when a covered entity, what it does with the PHI while the PHI remains within its boundaries, among its own people, among its own employees. When we refer to disclosing PHI, we're talking about when the covered entity shares that PHI with others outside of its boundaries. So in a nutshell, the only time that a covered entity is required to disclose PHI is to the individual themselves and to Health and Human Services during a compliance investigation. For all other times, a covered entity is, their disclosure could be permitted on their discretion in certain situations, and sometimes requiring the patient's consent first. So let's talk about those permitted disclosures, permitted uses and disclosures. In line with HIPAA's twofold goal of improving efficiency of healthcare delivery and protecting patient privacy, a covered entity may disclose an individual's PHI for treatment, payment, and healthcare operations. So this is known as TPO, treatment, payment, and operations. So a covered entity may disclose PHI to get paid or reimbursed for the treatment. Also, HIPAA permits covered entities to disclose individuals' PHI to healthcare providers involved in their care. Okay, it would be the T, the treatment. There are a number of situations where PHI can be used even without the individual's consent, such as when it's disclosed in public health emergencies, to report victims of abuse or neglect, and in certain law enforcement activities. Under some circumstances, a covered entity may disclose to a person involved in the health care of that individual PHI that's directly related to their care. These can be persons such as the individual's family members, domestic partners, friends, neighbors. And in a situation like that, when the individual is treated, when the individual who's being treated is present and has the capacity to consent, the person providing the treatment should get the individual's approval and give them a chance to object. When the individual being treated is not present, the person providing the treatment can use their best professional judgment to determine whether the PHI disclosure is in the patient's best interests. So obviously in both cases, the provider should first clarify the identity of the friend or relative, and best practices to document their actions here. When it comes to using and disclosing PHI, an important concept to keep in mind is the minimum necessary standard. This is the requirement that whenever a covered entity is using or disclosing PHI other than for treatment, the covered entity must make reasonable efforts to limit the use or disclosure to no more than the minimum necessary to accomplish whatever the goal is of that task. So only reveal the information that's needed. For example, let's say an insurance company asks a provider for information on the patient's visits during the past month. The doctor should only send the information from the past month, not the patient's whole treatment record going back years. So I find this minimum necessary standard concept helpful, even in the IT world, and as different units of the university work, at the point of collection too, where when we're collecting sensitive information, we should remember just to collect the minimum necessary for what we need to do. The less information we have, the less there is to have a privacy incident or breach. So let's say someone here works within a covered entity, and then someone outside of that covered entity is requesting a disclosure of PHI about a patient, about an individual, and a written authorization of the individual is required, because let's say the disclosure wouldn't fit under any exceptions. So this slide lists the elements of a valid written authorization by the individual. Description of the PHI, persons authorized to use or disclose it. That's the giver of the PHI. The persons who are authorized to receive it, and purpose and expiration date. You've probably noticed that HIPAA has a lot of terms that refer to very specific things, such as PHI and covered entity. Well, business associate is another one of those terms. When HIPAA refers to a business associate, it's not referring just to any other outside company or organization or person that the covered entity happens to be doing some kind of business with. There's a specific type of relationship that it means. A business associate under HIPAA is a person or entity that on behalf of the covered entity performs certain functions and services involving PHI. For example, financial services, legal services, administrative management. To really drive it home with the picture, Let's say the dental school here, the dental clinic, uses a telephone calling company to remind patients of their appointments. And they get a list of patient names, phone numbers, and appointment dates. So in that case, that calling company would be a business associate. Covered entities have the duty to ensure that business associates use that disclosed PHI in accordance with HIPAA. So HIPAA requires the covered entity to request a contract called a business associate agreement. And that agreement specifically sets forth the business associate's responsibilities and how they care and manage that PHI, including privacy safeguards and security safeguards too.
Lisa?
Yes.
Will it specifically state this language in the BAA as part of the template? And if it's silent on it, does that mean that it's not covered, or just by virtue of it being a BAA, the regulations confer this?
By using the term business associate, by signing that, and Michelle, correct me if I'm wrong, and you are making the representation that you are a business associate. So I'm going to get to that in a few more minutes. Only in very rare circumstances would Case Western Reserve be acting as a business associate. And in the research context, never or almost never. So the takeaway is if you're aware of anyone, or especially any researcher on campus, being presented with the business associate agreement and asked to sign it, contact Office of General Counsel or our office immediately. Okay, don't assume that just because another agreement may be appropriate if we're receiving data, but the business associate agreement may not be the correct one. Okay. And I think, Matt, you must have read my mind, because that was the next thing. I wanted to point out that we're a research university. We conduct a ton of research here, including human subject research. And most people, when I showed the slide about what our covered entities are, many people are surprised that the School of Medicine is not a covered entity because of our research. So in many cases of this human subject research, our hospital affiliates or other research collaborators share personally identifiable information with our researchers from their hospitals. To disclose, for them to disclose for research purposes, covered entities are usually required to get the written consent of the patient or authorization of an IRB. However, even in the absence of an individual's consent or an IRB authorization, there are some situations where HIPAA would allow PHI to be disclosed for research. And this slide delineates those. And as we just discussed, entering into a business associate agreement when acting as a medical researcher is usually not appropriate. And in such a case, we absolutely would want to acknowledge our responsibility in protecting the individually identifiable information responsibly. So in such a case, a data use agreement is normally more appropriate. Without saying that we are a business associate, in a data use agreement, we would be acknowledging our duties to keep the information private and secure. And in such a case, as with any agreement, if you or someone in your department or someone you're helping is presented with the data use agreement for signature, the appropriate office to go to initially is the Technology Transfer Office, and ultimately they'll review it with Office of General Counsel. The HIPAA privacy and security rules allow for the disclosure of PHI in the form of a limited data set without an individual's authorization or IRB approval, as long as you have a data use agreement. Okay, so that's where we often see data use agreements pop up. What is a limited data set? It's A limited data set is PHI from which those listed on this slide, direct identifiers, have been removed. So what is an example of a limited data set? This is confusing. So a data set containing, for example, birth dates of males born in a certain state with certain health conditions, that could be a limited data set. Okay, so that's one instance, Matt, where you might come across data use agreements.
Would genomic data be considered a biometric identifier?
Genomic data?
Yeah.
Yes, it can be.
Okay.
Yes.
One thing I'm a little unclear on is the medical record number or chart number. That by itself, is that PHI, just a chart number?
A chart number with health information?
No, not with anything else, just the chart number itself. Because I see medical record number up here, which refers to chart number, and just a chart number or a list of chart numbers just by itself.
Well, these are identifiers. So,
But it says medical record number.
But remember, to be PHI, it has to be connected to health information. So the identifier has to be connected to some kind of health information.
Just the chart number by itself is not
Just the way
PHI.
my name on a piece of paper is not
I
PHI.
mean, just like the chart number, if you see a manila folder sitting there with the number 1234R on it, just seeing that is not PHI.
I would say generally no, but could there be situations where one could identify? I don't want to say absolutely no, but
My concern is, I run a lot of reports for people. They, generate a list of patients that we saw last week. And I'll give them a list of chart numbers. Is that PHI? It's just chart numbers.
a list of names,
No,
a
not
list
names,
of chart
just
numbers.
chart numbers. Just chart
Yeah.
numbers by itself. It's just a list of chart numbers. Is that PHI?
Okay, so if it's a list, okay, it may not be, but if it's in an email with the subject line saying, patients we treated last month, then it probably would be PHI, or could be.
But it's just the chart numbers, nothing else.
So you're handing someone a page with a list of chart numbers, nothing else, not PHI.
But if it's any kind of context like that.
Could be, yeah, if there's, depending on the context, it could be.
Okay. All right, I'd like to talk to you more a little bit after.
There are certain situations where case personnel could legitimately receive PHI from an outside entity other than for research. For example, we could have an outside healthcare provider that may give a unit of case its organization's patient PHI for case to analyze its business operations, like to identify ways that it can improve. The case recipient of the PHI in that case should treat it with a high level of care and privacy and security. And in that case, BAA may be appropriate, but it's not for that unit to decide. As I said, they should contact Office of General Counsel or our office to get help with that. HIPAA places several significant requirements on covered entities. One of these is that each covered entity must designate a privacy official. This privacy official is the person who needs to oversee the covered entity's procedures and policies for complying and interpret how HIPAA rules apply to their actual day-to-day situations. So if you work within a case-covered entity, you should get to know your privacy official for when PHI-related questions arise. Another requirement that HIPAA places on covered entities is the requirement that each have written policies and procedures describing how it complies with the HIPAA privacy rules, including sanctions for PHI misuse. Those policies and procedures are supposed to form the basis for that covered entity's training of its workforce on HIPAA privacy so that each employee can properly carry out his or her functions. To protect the privacy of individuals' PHI, HIPAA grants several significant rights to individuals. And we're all sitting here employees of CASE, but we're also private consumers of healthcare. So this is of personal interest to us too. Individuals can request additional restrictions for confidential communications. So, for example, a patient can request that the treatment provider contact them only at work or contact them only at home. You know, they can make that request. Right of access to health records, right to request that the PHI be amended if appropriate, right to request an accounting of disclosures of PHI, and a right to file complaints on the way a covered entity is handling their PHI. If any of you here work within a covered entity and you receive a request from an individual regarding their PHI, it's a good idea as a first step for you to refer to your privacy official in the covered entity. And then if he or she has any questions or wants help in additional input before responding, they could contact our office or the Office of General Counsel. To promote individuals' awareness of their privacy rights in their PHI, HIPAA requires covered entities to have a Notice of Privacy Practices, an NPP. This document describes how covered entities use and disclose PHI. It explains individuals' rights regarding PHI and how they can get more information. Covered entities post NPPs prominently. For providers, the NPP is normally given to patients at first service, and patients are asked to sign it to acknowledge their receipt. The feds provide us with detailed guidance on how we are to comply with HIPAA. Health and Human Services recently released an updated risk assessment tool for covered entities to perform self-assessments. And risk assessments, these are required by the HIPAA security rule. The tool has 3 components that address physical, administrative, and technical safeguards which covered entities should have. Administrative safeguards focus on management practices and policies of the covered entity, such as whether the covered entity has policies explaining how it grants access to PHI to its workforce members, whether the covered entity signs business associate agreements with its business associates. This slide shows examples of technical safeguards, such as whether the covered entity identifies appropriate security settings for different info systems. Physical safeguards, yes?
So CASE has 5 covered entities. Do we have business agreements between those covered entities and other non-covered entities at CASE?
Best practice, if other operational units at CASE have access to PHI, best practice is to get BAAs in place. And we could talk.
Have agreements with itself.
That's kind of new, because we use ITS for data stores. And we've gone through, done the best, and done our due diligence to ensure that everybody's had some kind of training or whatever that accesses those data stores and they're properly locked down. We know who has access, but there is no BAA. The dental school does not have, as far as I know, a BAA with ITS. Do we need to get one?
To be consistent with best practices, if non-covered entity staff have access to PHI, that's what we would recommend. But we can meet afterward, either today or at a later date, to talk about the risk and talk about the extent of PHI, what the access is like. Would you have anything to add, Boyd, to that?
Yeah, so the privacy program, we've ramped up the privacy program. Really, it's come into development over the past year or so. So we are discovering areas where there are some gaps in best practice, and that's one of the things that's come out of these meetings, is we've identified areas where we've had opportunities to improve how we conduct business. So I would welcome anyone who has a concern to meet with us so we can evaluate and determine the appropriate next steps.
As you've talked about best practices and that, is your office actually auditing any of the covered entities to make sure that their policies and best practices are documented?
We have We have started working with the covered entities to have them start doing those HIPAA self-assessments.
That will be helpful.
Yeah. And looking at the physical safeguards, they're really very common sense, but unfortunately, sometimes just out of habit or laziness, it's easy to overlook even the most basic physical safeguards that would make a big difference. You know, locking up sensitive documents, the example with speaking about PHI in an elevator, you know, not doing things like that. Other examples on this slide. So the HIPAA self-assessments help covered entities consider its comprehensive privacy practices. Basic tips for helping employees here at CASE properly manage PHI and other sensitive data that may not be PHI, bulleted on these next couple slides. Don't leave documents containing PHI or sensitive information out in the open. Fax machines, printers, things shouldn't be left there over time. Things should be promptly picked up. We talked about keeping conversations private. Closing and locking the computer screen so that someone walking by can't view sensitive information on your computer. This last one is more important than one might initially think. Shredding documents that contain PHI or sensitive information. And I know that here at CASE, we have a shredding service. So by shred, I mean place in the collection box for the shredding company to do. So what's the risk of putting a sensitive document in the trash or the recycling? Is anyone really here going to rifle through the trash or recycling containers? Probably not. But what happens when, you know, in the disposal process, it's dumped out, the dumpster is full, it's a windy day, and, you know, these documents, you know, worst case scenario, blow all over, containing Social Security numbers, private information. You know, it's not something we want to do. It's not something we want to cause. We don't want to have that originate with us. So if in doubt, I always stick a paper in the shredder instead of, you know, the other disposal things. More tips. Well, many of you are IT folks, so you probably know about more and more up-to-date even security practices than I do. But you know, again, sometimes these seem obvious, but bear repeating about not sharing passwords, not posting them by or near the computer. When emailing, be cautious about what you send. You know, this is a email, and I know that Tom is this is a subject close to his heart too. That's just an area that's open to possibilities of unintended disclosure. So use extreme caution. Yes, Andrew.
Quick clarification of the first line up there. Do not store PHI on personal computers, cameras, devices. Does that mean non-university owned? When you say personal?
That does mean non-university owned.
Okay.
Yeah. So, you know, maybe 20 years ago, people weren't bringing their own devices on campus, but now people are. People, you know, it's a different, we work differently now. Folks shouldn't be ever have any PHI, you know, from the dental school or, you know, from HR here on their smartphone or on, you know, something that stores it on there. So it's a reminder. We talked about what some of the potential harms could be if there is a breach. For us, any breach of private information has a potential to result in serious losses, either originating from paper documents or electronically stored information. You know, disclosure of personal information. Okay, so you could be embarrassed, or worst case scenario, identity theft. Could result in case getting a tarnished reputation in the community. Privacy incidents could result in loss of trust and loss of confidence, among our students and among our faculty and staff. Depending on what the information or data that was lost, we could lose IP, lose our intellectual property. Also, loss of time and resources in responding to breaches. Also, legal sanctions can be severe. Because of these potential harms, we place a very high priority on the security of our information to prevent breaches. And part of the prevention plan includes having a privacy office and doing all those things that I described at the beginning of the presentation about what we're doing. Even with strong awareness and good privacy practices, though, it's unfortunately still possible to have a data breach. So it's important to have a consistent method to contain and respond to all information breaches, PHI and non-PHI. Our goal is to investigate and respond appropriately to each breach, depending on the level of potential harm, the legal obligations that might be involved to each particular situation. If a breach happens and it's reported to the privacy office, we'll investigate it. And best case scenario is that initial report was a mistake. There wasn't actually a breach, so we would document it and the process would end. If there was a breach, then the privacy office works with the affected office to contain it, assessing the extent and impact. And the privacy office may also bring in other offices. We frequently work with IT security if the breach involved electronic information. After containing the breach, the privacy office would confer with general counsel to determine if any specific legal protections were attached to the breached information and to identify any reporting obligations we may have. We'd work together to identify all laws that may impact our response, plus any contractual obligations we might have. An important part of this discussion is for the privacy office to analyze the risk of harm to individuals affected by the breach. So based on these considerations, the privacy office often sends notification letters to affected individuals. The privacy office identifies whether there were any other institutional harms that would need to be addressed and would work with the affected groups there to kind of foster an improvement of processes. Part of this breach response process includes the privacy office drafting a breach report, which would include the relevant facts of the breach and our response, the university's response, and our office maintains that breach report as a tool to fulfill reporting obligations. To wrap up the presentation, I leave you with the thought that everyone in the case community has the duty to uphold privacy, but you're not alone in your responsibility. Please contact me or Boyd Coomer, the Chief Privacy, Export Control, and Security Officer, Compliance Officer, and we would be able to come to your school or come to your area or meet one-on-one with you and address any specific concerns that you have. Thank you for your attention.